So welcome to those of you who are joining. We're just going to wait about 30 seconds. We have over 400 registrants for this program, so it takes a little while for Zoom to load you all in. So we'll give it about 20 more seconds and then I'll kick it off. Okay, I think we're good. Let's go ahead and dive into our conversation today. I'd like to welcome everyone who is joining our program today. We have over 400 registered participants for this afternoon's conversation about the High War Crimes Tribunal for Ukraine. We're excited to spend the next hour together with our 6 distinguished panelists and our 1 guest appearance to have a conversation to think through what a high war crimes court might look like for Ukraine, and to dive into some commentary on a draft statute that was prepared by PILPG, Weil Gotshal, and a number of our Ukrainian colleagues who are here with us today as well. My name is Paul Williams, and I'm a professor of law at American University, and along with Michael Scharf, I'm the co-founder of the Public International Law and Policy Group, and also the president of the Public International Law and Policy Group. PILPG is a global pro bono law firm which provides free legal assistance to parties involved in negotiating peace agreements and in designing mechanisms for prosecuting those responsible for atrocity crimes. Today's expert roundtable is part of our series of Ukrainian roundtables and it aims to discuss and focus the conversations on developments in the Ukrainian-Russian war, ponder complex legal questions related to those developments, and inform the audience of important international legal principles, and have a conversation about the applicability of those principles to the war between Russia and Ukraine. We hold these roundtables every other week from 12 o'clock to 1 o'clock Eastern Standard Time. For today's expert roundtable, the representatives from the working group are comprised of Ukrainian and international experts, and they will present and discuss a draft legislation for the High War Crimes Court for Ukraine. The roundtable will be 60 minutes long. Our distinguished panelists include Professor Dr. Tetiana Ansipova, Dr. Rasim Babenli, Levgeny Aryshchenko, apologies for my pronunciations there, Glenda Lieberg, Ambassador Stephen Rapp, and Michael Scharf. We also have Katerina Kyrichenko as a special guest appearance to kick off with some initial context in just a moment. The presentations will be recorded and posted on our website. And if you have Q&A questions, go ahead and post them in the Q&A function. We will either answer them live or the panelists have the discretion to chit chat while other panelists are talking and answer your question, or some of the PILPG Ukrainian team members may also answer your questions in the Q&A. So don't be shy and jump right in with any questions you have whenever you feel up to it. So let me introduce our panelists. We have Professor Dr. Tetiana Ansipova, who's been working quite extensively with PILPG over the course of this past year. She is a judge of the Supreme Court of Ukraine, and before her appointment, she was a head of the Department of International and Comparative Law at the Humanitarian University in Odessa. So welcome, Tetiana. We also have Levgeny Laroshenko, an analyst and advocacy officer at Crimea SOS, a leading Ukrainian NGO which monitors developments in Crimea and provides various types of assistance to victims of human rights violations in the occupied territory. Also, welcome, Levgeny. We also have Rasim Babenli, the head of the Department of Analytical and Legal Work of the Supreme Court, dealing with both civil and criminal cases. Welcome, Rasim. And also joining us today is Glenda Lieberg, a consultant in Weil Gotshal's complex commercial litigation practice in the firm's Washington, D.C. office, and she has extensive experience in matters involving international law and human rights. We are honored to have Ambassador Stephen Rapp join us. He is a senior peace fellow with the Public International Law and Policy Group, and a few other things other than that. But he was also the former chief prosecutor for the Sierra Leone Tribunal, where he prosecuted former Liberian President Charles Taylor, and he served as the Department of State's ambassador at large for war crimes. And wrapping up the batting list is Michael Scharf, Dean Michael Scharf. He is the co-founder of PILPG and the co-dean of Case Western Reserve University School of Law. And we have Katerina Kyrichenko, who is a member of PILPG's legal team and based in Ukraine. I would also like to provide a warm welcome to Andriy and to Sasha, our interpreters, who will be making us all sound much more articulate in Ukrainian than we are in English. Some of our panelists will be speaking in Ukrainian, and some of our panelists will be speaking in English. We have about 1/3 of our registrants are Ukrainians and 2/3 are English speakers. So be sure that you click in the lower right-hand side on the Zoom channel for the globe and check either English or Ukrainian as your preferred language as listeners. So before I turn to the panelists, let me turn the microphone to Katerina to provide an overview of the expectations of the Ukrainian people with regards to justice and accountability. What is on the minds of the people of Ukraine? What do they want? And what do they see as, quote, justice and accountability? Over to you, Katerina.
Thank you, Paul, for the question. Since we are talking about Ukrainians' expectations, let me respond to your question in Ukrainian. В Україні вже 8 років триває
In
війна.
Ukraine, the war has been ongoing for 8 years, this Russian war. It's unprecedented. That's why the demand of Ukrainians for justice and accountability is also unprecedented. The expectations of Ukrainians who suffer from the ongoing war are that those guilty of crimes on the territory of Ukraine will be brought to justice, that there are guarantees that the crimes committed during the Russian war in Ukraine will not go unpunished, and that the persons who started this unprovoked war will not enjoy impunity. Today's crimes are a direct consequence of the world's passive reaction to war crimes and human rights violations in the past. That's why it's important that the efforts of justice bring results now. The process does not drag on for many years. That is why the efforts of the Ukrainian authorities and international bodies are aimed at collecting, documenting, and preserving evidence, which should lead to the prosecution of those guilty of war crimes and other atrocities. Ukraine, together with its partners, seeks to unite collective actions so that those responsible for these crimes, including the direct executors and the leaders, are brought to justice in the court of law. War crimes, crimes against humanity, and the crime of genocide committed on the territory of Ukraine by the citizens of Russia fall under the jurisdiction of the International Criminal Court, and the investigation is underway. However, due to a number of limitations, the ICC does not have sufficient powers to investigate and prosecute individuals for committing crimes of aggression, specifically against Ukraine. But the crime of aggression is key, because if there was no Russian attack and unprovoked war, then there would be no subsequent war crimes. Therefore, now Ukraine is working more with what results from the crime of aggression: murder, torture, enforced disappearance, deportation, rape, etc. So the creation of the tribunal, a separate tribunal specifically for this aggression, will fill the gap. It's important to note another aspect. The Ukrainian authorities and the Ukrainian people call on the international community to recognize Russia as a state sponsor of terrorism due to unprecedented nature of the war it wages in Ukraine. While in the east of the country, the soldiers on both sides of the front line are trying to gain to gain control on the territory, but in other parts of Ukraine, it is something else. It looks like terrorist acts because the violent actions which happen in Ukraine are aimed at the intimidation of the population and at affecting the policymakers through these violent actions. And there are numerous examples for that, such as the bombing of Kremenchuk on June 27. An anti-ship missile, Ha-22, has hit a shopping center, killing at least 20 people. There was the repeated use of cluster munitions in the residential areas of Kharkiv, bombs which split into hundreds of fragments, causing death and injury, leaving traces in playground and yards. The July 10 attack on Chasiv Yar in Donetsk region, where numerous rockets hit a 5-story residential building, killing 48 people. Also, the recent rocket attack in the center of Vinnytsia in July 14, 23 people were killed, among them 3 children. These are numerous examples of what's happening in the territory of Ukraine now. And today, Ukraine defends not only its sovereignty and territorial integrity, but also the key civilizational principles of freedom and justice. Therefore, Ukrainians hope for effective international support in the investigation of crimes committed by Russia in Ukraine and reaching justice. Thank you, and back to you, Paul.
Thank you, Katerina, for that very articulate description of the needs of the Ukrainians, for the Ukrainian people, for accountability and justice. Let me now turn to Michael. And Michael, could you help walk us through how this proposal for a high war crimes court for Ukraine could help to meet the needs for accountability and justice that Katerina just articulated, and also provide us a little background about the working group which prepared this draft statute? It's only been 2 years of Zoom, Mike.
Hi, Paul. Thank you very much for that introduction. And I will begin by thanking the team from while there was about a dozen lawyers who really did a deep dive into the Ukrainian law and international law and have been extraordinarily helpful. The PILPG team, and especially the Ukrainian experts. So for the last 2 months, we've been working on this project. We've had a series of meetings, and we think we have produced a document that is going to be very helpful. Let me begin by telling everybody about some late breaking news that sets the stage for this. The first is that the UN Office of the High Commissioner for Human Rights just released the most recent update of the casualty figures. And they're saying that 11,000 people are documented to have been killed, 11,000 civilians, and almost all of these are going to constitute war crimes. The second thing is that the destruction which Katerina was describing is vast. So we have apartment buildings, hospitals, schools, churches. It's really about the most extensive since World War II, and each of those are war crimes. The third thing is that the Ukrainian Prosecutor General has announced, interestingly, on Facebook, that they have received information about 21,897 war crimes committed by the Russian military since February. And the final thing hot off the press is that the United Kingdom just announced that it will be providing 2.5 million euros in assistance to the Ukrainian Prosecutor General for war crimes investigations. Now, that's all good news. And the investigations around the world are really happening at a torrid pace. There's just a mountain of evidence that is coming in. And the kind of evidence has been everything from photos, videos, telephone intercepts, witness interviews. And so there is going to be no shortage of documents to prove the war crimes cases. There is, however, an accountability gap in the hierarchy, and that's why we launched this project. So Katerina mentioned that the International Criminal Court has this investigation, and we all know 2 things about the ICC. One, it only will prosecute a couple of top leaders because it is responsible for situations all over the world and it has limited resources. And the second thing is it cannot prosecute the crime of aggression for Ukraine. So now the second level in the hierarchy is that there are efforts to create a hybrid tribunal for aggression. And Stephen Rapp, who's with us today, has been very involved in those efforts. One strand is a Ukrainian United Nations General Assembly created hybrid tribunal. Another would be a Ukrainian hybrid tribunal created with the EU. Again, that would only be prosecuting the crime of aggression, which is a leadership crime. So we're talking about the top level people. That means that there are thousands of people below that that need to be prosecuted. And most of them will be prosecuted in Ukrainian courts. And I believe the Ukrainian courts will be able to fairly and effectively prosecute the foot soldiers and the low-level people. They've already had a couple of trials where people have said that they admitted their guilt and they were convicted of crimes against civilians and given life sentences. The real challenge is going to be when the people that fall into custody in the Ukraine are high or mid-level, the generals, the colonels, the majors, the lieutenants. Those people are going to be difficult to try fairly because they're foreigners, because the world will be watching, and because they're challenging cases. And so around the world, the best practice in this situation is to create internationalized domestic tribunals. And at first we were thinking about creating a hybrid tribunal for this purpose, but what we learned is that that would be extremely difficult under the Ukrainian constitution, which cannot be amended during times of conflict. What we did find out in our research and all of our meetings was that there is a model for what we wanted to accomplish, and that is the Ukrainian High Anti-Corruption Court. It was established by law in 2019, and there hasn't yet been as much political will in favor of that as there would be for a war crimes court, so it has been slow to get off the ground. But legally, it gave us the background to develop a court that does what we think would be extremely helpful in filling the gap. And what you're going to hear in a few minutes are all the different provisions that we have been working with to make this court an effective court. And our hope is that after this public launch, and of course, we put our statute online so people can look at it, that we would have a series of meetings and then the Ukrainians and international community would run with this ball. Thank you, Paul.
Great. Thank you, Michael. Let me now turn to Tatiana. And if you could provide a little additional background about the ongoing accountability efforts in Ukraine. Both Michael and Katerina have touched on some of the big picture efforts, but if you could provide us a bit more of a granular detail about what's actually happening on the ground in Ukraine with respect to prosecution of those suspected of atrocity crimes.
Thank you very much, Paul, for the opportunity to speak. I apologize for not being able to use my camera. I really hope that you can hear me. And if that's the case, I will gladly comment. So once again, sorry for lack of video here on Zoom. Dear colleagues, dear PILPG team, I really appreciate all the efforts you invested in this issue of accountability, which is so important for Ukraine. We thank you for all your work and efforts. Let me say that whatever I say today, this is my personal, private opinion, not the position of the Supreme Court of Ukraine. So now down to the point, what's going on in Ukraine, what kind of efforts are ongoing towards prosecuting the persons who have committed the war crimes. Let me say that the Office of the President of Ukraine and the Ministry for Foreign Affairs and the Association or Ukrainian Association of International Law initiated this establishment of the specialized tribunal to prosecute for aggression, crime of aggression, because the ICC does not have jurisdiction over this kind of international crime. For almost 5 years, we have been having hot discussions on both on international level and on the level of EU, of European Parliament, and so on. We have already 2 resolutions signed supporting this initiative to establish this tribunal, and the headquarters of such tribunal should be in The Hague. This should be an international court according to its nature. And in parallel to that, we have discussions about the resources that would be necessary to launch the work of this tribunal. These both include financial and human resources. I would like to highlight the efforts of the Ukrainian Association of International Law. Mykola Gnatovsky, who is the vice president of this Association of International Law, made a lot for this. Later, he was nominated to the European Court of Human Rights. Now, Anton Kurinevich has replaced him. He is also a member of the Ukrainian Association of International Law. Speaking of the ICC and the case that has been launched on the level of ICC, you all know that the prosecutor of the ICC has visited Ukraine several times and is in close cooperation, is working closely with the General Prosecutor's Office of Ukraine. And the Prosecutor's Office of Ukraine seems to work fruitfully with the ICC prosecutor. These 2 areas of work seem to be optimistic for the future. Thank you for your attention. I hope I have answered your question.
Great.
Maybe my other Ukrainian colleagues would like to comment some more.
Thank you, Glenda. Thank you, Tatiana. That was perfect. We're now going to turn to Glenda for a big picture question, and then to Rasim and Evgeny, and that'll give them a chance as well to extrapolate and expand on what you had to say, Tatiana, as well as some additional comments. But Glenda, let's turn to you for a moment, and if you could walk us through some of the big picture questions that you and your team were faced with when designing a high war crimes court for Ukraine. How did you end up with this particular model, and what challenges were you addressing or pitfalls were you trying to avoid?
Sure, thanks, Paul. So good afternoon before everyone. I will, before I answer your question, Paul, I would like to take a few seconds to acknowledge and thank PILPG for this amazing work you have done in this project, and for giving us the opportunity to help in such an important project. I also wanted to thank the WILD team, working on this project, partners, Daniel Dokus, Chris McCara, associates Tessa Latosky, Destina Reyes, and Kristen Adamson for the wonderful work we have all done during this time, but for their participation, which is absolutely impossible for me to be here without all my team. In any event, as Michael already mentioned briefly, we started working on this project several months ago, and we started working with a draft for a hybrid tribunal. Then it became quite clearly after that, that was not much feasible, and also because there were some other accountability mechanism that were considered for Ukraine, that there was a gap within those mechanisms, and that, as he mentioned, for the higher to mid-level officials to be prosecuted. So we started working with our colleagues and within the framework of internationalized domestic tribunal. And then we realized that that kind also was going to get some tough challenges from within the Ukraine. So we ended up and we moved on to work, and follow the model of the High Anti-Corruption Court that was already established in Ukraine. We have been very closely working with our Ukrainian colleagues, and we have tried to address all their concerns in this law. And so we have the hope that this tribunal will face, this court actually will face less challenges, and that will be up and running relatively soon.
Thank you, Glenda. Let me now turn to Rasim and ask, how would this high court for war crimes fit within the Ukrainian judicial system? And can you discuss the potential of this court from the perspective of the High Anti-Corruption Court that has recently been set up in Ukraine?
Thank you very much, Paul. I really appreciate the work organizers have done to have this Zoom call. It's a very relevant and hot topic. We all have the important issues at stake to discuss. As for the judicial system of Ukraine, I think that the model suggested now is fitting our judicial system very well. Let me just say a couple of things. The High Anti-Corruption Court was established not without trouble, so to say. Why? Because none other European countries has anything similar. And as we can see from practice, theory does not always have all the answers to questions we face. And now we see from the practice that the High Anti-Corruption Court of Ukraine earned the trust of the public, and it works, it functions very well. So this element that seemed very novel and very new did its job, and now this anti-corruption court, High Anti-Corruption Court, works very well. And that's why I believe this model would serve just as well for our purposes for the High War Crimes Court. And I'm sure we would benefit from considerations of all the plus sides of the existing High Anti-Corruption Court of Ukraine. So I can say that if we implement this project and the idea you were mentioning today, prosecuting those who have committed war crimes, if we do that, we will achieve the goals we have. Thank you.
Thank you, Rasim. I appreciate those thoughts and comments. Let me turn it now to Evgeny and ask you if you could share with us your thoughts on whether or not this type of high court would facilitate the commencement of prosecutions in Ukraine and to help address the significant number of cases that presumably would be pending.
Dear Paul, thank you for giving me the floor. First of all, I would like to express my gratitude to the PILPG team for considerable efforts aimed at fighting impunity for a huge variety of atrocities happening in my country. I highly appreciate draft text of the High War Crimes Court for Ukraine, and I'm confident that such an initiative could break the ice and it would be a great step towards bringing perpetrators to justice. Ukrainian society places much hopes in the International Criminal Court. However, a primary responsibility for the investigations and prosecutions of international criminals is placed on national authorities. As of today, we have a situation when during the first 6 years of Russia's aggression, courts announced only 2 sentences under Article 438. It's violations of the laws and customs of war. In my view, the establishment of the High War Crimes Court could at least cover 2 domestic gaps. First gap is that such a court would complement domestic judges with persons who have necessary experience in international humanitarian law and international criminal law, because the current judges who on their daily basis consider administrative cases, civil cases, ordinary criminal cases, and at the same time they consider cases of war crimes, they do not have enough experience particularly focused on the current context of armed conflict. Second gap is that why many the reason for the ongoing lack of justice is that many war crimes are not correctly classified. For instance, a murder of a prisoner of war sometimes is classified as an ordinary murder. Therefore, the establishment of the High War Crime Court could help also to better classify such crimes in accordance with the existing Ukrainian legislations. However, the establishment of this court is only half task. Another one challenge is that Ukrainian legislation is not harmonized with international law. As aforementioned, Article 438, violations of the laws and customs of war, it's a blanket article, which means that judge, prosecutors, and other participants of the judicial process should open up to certain international treaties in order to find out what is the violations of international treaties. Therefore, it should, another step is harmonizations with international humanitarian law and international criminal law. We do not have such notion as crimes against humanity in Ukrainian criminal court. The crime of aggression is not properly defined. We have waging of aggressive war, but its definition is far from what is in the Rome Statute and respective UN General Assembly resolutions. As of today, we have 2 draft laws on harmonization of Ukrainian legislations. One which was adopted in June 2021, but for unknown reasons, the president has not yet signed it. He neither vetoed nor signed it. And another one, 7290, which is a stripped down version of the previous draft law, but it's still not, has not been considered by the parliament. So of course, High Court is a huge step towards fighting impunity, but we also should focus on necessary legislative amendments. Thanks.
Thank you, Evgeny. Let me turn to Stephen now and ask if you could enlighten us as to whether similar types of courts have been established in other conflicts, and what do you see as the benefits or the drawbacks of this type of proposed tribunal?
Well, thank you for the question, and thank you for the opportunity to join you in this drafting process and in today's seminar. This idea has been deployed elsewhere and used effectively. and in situations where there was an international tribunal with the authority to prosecute the very top level offenders. There was a recognition eventually that for the more mid-level individuals, and the people aren't necessarily the direct perpetrators, the shooters or the torturers or the rapists, but people that bear the responsibility for sending out folks to do those things and knowing that they're doing them, and that being part of a strategy. The developing those kind of cases is a very complex business. And it's not like an ordinary bank robbery or other kind of crimes. And it is a wise thing to concentrate the talents and the expertise within specific courts, particularly for those kind of organizational cases which need to be investigated, where someone's participation, they never have blood on their hands, but they're responsible. And there are various ways under international law you can attribute those responsibility. And though not all of them are incorporated yet in Ukrainian law, some of them are. And so it makes a lot of sense to have a court like this for those mid-level offenders. Now, other places where this has been done, in the tribunals established by the Security Council in the 90s for Yugoslavia and Rwanda, they had primary jurisdiction for the war crimes and crimes against humanity and genocide committed in those situations. And eventually prosecuted a great many top-level people. 161 were charged at the Yugoslavia tribunal, 85 at the Rwanda tribunal. But even then, there was, and certainly pressure for them to complete their work, those tribunals, and to defer to cases back in the countries where the crimes had been committed and to transfer some of those cases back. And there was a recognition that even while those countries had primary jurisdiction to deal with lower level offenders, it made sense to have specialized chambers. And so we had in Bosnia the very effective war crimes chamber, which additionally had international judges, but they were phased out by 2012. And they prosecuted senior officers and political leaders and others for responsibility for genocide and war crimes and crimes against humanity committed in Bosnia. In Serbia, for instance, a special chamber was established, not with internationals, but with specialized knowledge and a special prosecutor to proceed against cases there, frankly, of Serbs who committed crimes against others. And that has achieved, and as my former deputy Dan Ornlicker said, it was one of the ways in which some of the denialism was eliminated or reduced that followed the crimes committed in the Balkans. In Rwanda, they established a special high court with jurisdiction for the transferred cases, both from the tribunal and from international jurisdictions. And even now with the ICC, and of course, the ICC has never prosecuted more than 6 individuals in any country situation. Usually the number has been smaller than that. And there was a recognition in the Central African Republic that there was a need for an intermediate court. And so one was established with at least a minority of international judges. So this kind of method has been done elsewhere, and it's been proposed, for instance, very actively in the Democratic Republic of Congo and elsewhere. And it does, I think, make a great deal of sense. Now, where I see the real advantage, as I indicated, is in this kind of specialized knowledge and expertise. And we're also looking, we hope, for a more unified and strategic approach to these cases. I mean, one of the challenges, and we hear the number now, close to 22,000 cases of war crimes, 200 or 300 more coming in each day, that suggests sort of a one by one kind of approach. And we know that not all these cases are created equal. And there's a need to develop an organizational, thematic, geographic sort of approach to the crimes, and to develop an analysis of the structure of the organizations and of the units or the mercenaries or others that are committing these crimes. And then to have that kind of structure that then when individuals are arrested, can put them in that structure, and the evidence is ready to largely about the context. It's necessary then to connect them in various ways to those crimes. And being able to do things in a more strategic approach, I think, is one of the real advantages of this. I do see it as a disadvantage, and I wish there was some way to overcome the inability to bring in international judges, because I think that could be particularly valuable in the cases of aggression if we don't end up particularly with an international hybrid tribunal for the crime of aggression for senior leaders, because obviously everyone in Ukraine, I was just there 2 weeks ago, see the enormous suffering of the whole country, and not always because of the war crimes. Indeed, even as soldiers who are fighting on the front and they're being killed and their families are affected, they're victims of the crime of aggression, even if the shot taken at them was not a war crime because it was against a combatant. And I'd like to see those cases prosecuted, at least against up to the highest level you can under international law, perhaps the chief of staff of the Russian military. And of course, if those cases are prosecuted by individuals who are victims of those crimes, as much as we respect the victimhood, people will want to see the cases more internationalized so there isn't any kind of appearance of bias in that situation. So I think there would be advantages if we could somehow find a way to change the Constitution or some kind of provisional act to be taken to include that, at least for certain classes of cases. But even if we don't, I think that with the legal advisors that we'll talk about in a little bit, we can accomplish some of the same things.
Great. Thank you, Steve. Let me now turn to Michael and ask him a two-part question. The first is Michael, if you could elaborate a little bit on what Stephen had indicated in terms of the types of individuals that might be prosecuted. You know, there's 21,000. Presumably they wouldn't do the 21,000. Presumably the high level would go to the International Criminal Court. So give us some examples of the types of individuals that might appear before this tribunal. And if you could also address in parallel a question which has come up in the Q&A about how does one ensure the impartiality of this type of tribunal. And Glenda, we're going to turn to you next to ask about international participation. So Michael can call a friend and you can help him out on answering that as well. But if it is based on Ukrainian law and then international law to the extent that it is incorporated into Ukrainian law, how do we ensure impartiality for these individuals that would be subject to the jurisdiction of this court? But you have to come off mute so we can really understand how brilliant you are.
I apologize. I'll start with the second part of that, and I'll ask Glenda to join me for some details. But as Stephen said, you know, originally our hope was to have international judges. That would be the best practice. But what we learned is that that is not compatible with the Constitution of Ukraine, and we cannot have the Constitution amended during a time of conflict. So what we did is looked at the second best approach internationally, and that is to have international training of the judges, international advisors to help the judges research the cases, draft their decisions and opinions and judgments and appeals, and also to work with the prosecutors and the defense counsel. And then finally, there'd be international observers. And that is very important to make sure that the whole world can see what's going on there. Additional elements that are important is heightened security, because we don't want these judges to be threatened. We want to harden the facilities so that they're not concerned about their security when they're making decisions. And most important to all of this is international funding. And the more international support and involvement, the more the international funding. So we heard that there's 2 million from the UK. They really need at least 50 times that. And I believe that with this structure, the money will come. And that's a very important part of ensuring the effectiveness and fairness of this court. To answer your question about the types of individuals, I alluded to this before, but you know, you wouldn't prosecute people one by one. You'd probably prosecute them in groups because they're involved together in different crimes. And the different crimes might be specific to locations and time. They might be specific to a strategy or tactic. But I believe that there are going to be a lot of generals and colonels and captains and majors that are going to be difficult cases to prosecute in an ordinary court. And those are the types of mid to high level military officers of Russia that would be appropriate. And the way this court is designed is that the prosecutor's office of Ukraine would decide which cases would go to the ordinary courts and which cases would go to the high court, so that there isn't a debate and a conflict between those two court systems. Glenda, do you want to add anything?
Sure. I mean, I think there's a point that Evgeny and Stephen brought up, which is the one of a special, you know, the prosecutors for this court are to be specially trained in international criminal law. So this would be, and there's actually a feature of this court where they will continue to have training during their tenure. So there's one thing. The other thing I wanted to say, we're also going to have, we added here also international advisors, not only international legal advisors, there's a public council of international experts that will be there. I think that's another feature of this court that, you know, that was before in here, but now it's adapted to international criminal law issues. And we also are going to have international observers. So we also included those in the issue of funding. We have included a special donors committee in this court, which was not previously in the High Anti-Corruption Court, with an oversight board that, you know, would include members of parliament and some members of the civil society in Ukraine, to make sure that the funds go where they need to be. But I think that's, we're also included here English as a working language, not as an official language, but because the official language would be Ukrainian, but as a working language, because we're going to have all these legal advisors supporting the court. And we're also probably going to have a big chunk of evidence brought in by international organizations that are present in Ukraine that are gathering a lot of evidence in this cases. And so that's why we also included English as a working language. I think I would leave it there for now. And if you have other specific questions, I'm happy to address those.
Great. Thanks, Glenda. Our audience are very active in the Q&A, so feel free to ping some additional questions in there. I know our team is answering some of those questions, and Katerina has jumped in and answered a couple. So keep feeling free to ping questions in the Q&A, and we'll answer them. Let me turn and ask Racine and Stephen the same question, starting with you, Racine. What would be the most appropriate and the most beneficial type of engagement of international actors? Clearly, this is a domestic tribunal, but given the nature of these crimes and given the experience of the international community, there's presumably some value add by having international engagement in this high court. From your perspective, what's most appropriate, most beneficial? And then Stephen, if you can just pick up after Racine speaks, and from your perspective, having done this for the past 20 years, what would you suggest as most appropriate and most effective? Racine?
Thank you very much, Paul. Today, my role is to speak about Ukrainian know-how. Recently, we have seen strengthening of international community in the Ukrainian judiciary, like this High Anti-Corruption Court of Ukraine. It was launched into functioning, and during the hiring or appointing the judges, international component was also there while taking the decisions. Today we have two bodies, this board to select judges for Ukraine, and the second body is the ethics committee of ethics. Both of these two bodies have international experts. 50% of each body has international experts, and they play a very significant role in decision making. So what does it yield? We align our practices with the best practices on international level. That's number one. Number two, we ensure this international transparency in Ukraine. And this, of course, helps us build trust on the international level, in international community, legal community. We don't want to be seen as unobjective or implementing bad practices. As for the High War Crimes Court, we have to ensure it is built on the same principles. As it was mentioned, representatives of international organizations or international legal experts would not be able to work as judges in this court. Despite this fact, they will have a significant role to play in the work of this court. The violation of international conventions, the fact of these violations requires deep understanding and broad expertise of these conventions and law. And international expert participation would give us just that. As Glenda said, we will have this interoperability, so to say. As for the impartiality of this High War Crimes Court, I believe the participation of international experts would be just the element we need to ensure transparency and impartiality, despite the fact that the judges will only be selected from among the Ukrainian specialists. This is not going to be done through oversight. No, it's going to be like insiders' stance in our international colleagues, and these would be not some people coming to Ukraine only once. No, these would be.
І чому вони так ухвалюються. Тому я гадаю, що саме такий механізм, він є
developments in this field, and I'm sure this is going to give us a chance to find the fine balance we need in order to administer justice and prosecute the guilty. And also we would ensure this a fair trial, very basic principle for us. And I'm sure this model has huge potential in terms of reaching the goal we all have and share in common.
Thank you, Rasim. Over to you, Stephen. And then
Yes,
I have a question for Evgeny and Tatiana.
Yeah, I mean, I see enormous advantages in having internationals. Every time I go out and get involved with national judges in this area, I discover they have a good intuitive sense of what criminal responsibility is about in these cases, but they often don't have the basis in precedent and in prior situations where it was possible to look at particular kinds of evidence to show active participation or aiding and abetting or common purpose responsibility, et cetera. And I think this could greatly improve the quality of the judgment. One frankly expects cases to be criticized. We know the Russians are going to put on these well, I hope they don't, but they're talking about doing the most uncredible, lacking in credibility kind of cases, show trials involving the defenders and the Azovstal steel plant, put them on trial for what? How could they do anything when the bombs are raining down on them? But they will, they'll find something, and they'll be doing, of course, a show trial with no basis. And when other cases are done in Ukraine, if they're not done on a very high standard, if it's not shown under international precedent and standards, why an individual who doesn't have blood on his hands is responsible, I think that will weaken the support that Ukraine has. So I really do see it of great value having these experts, and we've seen it in other situations where we talked about the Iraqi High Tribunal where Michael was involved, and I know there was criticism there basically on the death penalty issue. But if you read judgments like the judgment on the Anfal campaign, 1,000-page judgment, it's a fantastically excellent judgment analyzing the genocide against the Kurdish people under the Saddam Hussein regime and convicting senior leaders. So it's very important to be able to do that, both the justice be done and seen to be done.
Great. Thank you, Stephen. For the remaining 5 minutes, let me turn to a two-part question for Evgeny and then Tatiana. Evgeny, we picked 2013 as the temporal jurisdiction of the tribunal as opposed to 2022. For those that are not deeply familiar in our audience, that are not deeply familiar with the conflict in Ukraine, can you walk us through why it's important to pick 2013 as the jurisdictional date? And then we'll turn the microphone directly to Tatiana. How are we going to pay for this? What ideas are there for funding this type of tribunal, and what is your experience in the past with raising revenue and funding for these types of ad hoc enterprises? Evgeny, over to you first.
Well, it's disputable whether the court should cover developments happened during the Euromaidan protests, because they were happening in the domestic context, which is different from the one which started in late February 2014. Our organization was established in late February 2014 during the first day of the occupation of the Crimean Peninsula. So since that time, we've been monitoring gross human rights violations, which are also allegedly fall under the definition of war crimes and crimes against humanity. Therefore, for us, it's our position that such a court should indiscriminately cover international crimes happening in Crimea since 2014, the crime of aggression, so that individuals who were responsible in the committing crime of aggression, political and military perpetrators could be brought to justice by means of the proposed High War Crimes Court, or by means of the currently discussed International Ad Hoc Tribunal, as well as with regard to war crimes and crimes against humanity. If we look at preliminary examination reports of the International Criminal Court, we can see that 8 types of war crimes which allegedly happened in Crimea are mentioned, as well as 6 types of crimes against humanity. Just a fresh case which recently occurred. This month alone, 4 Crimean Tatars have been sentenced to long prison terms in a court in Rostov-on-Don. So they became victims of war crimes in the form of forcible transfer outside the occupied territory, and they were allegedly illegally confined under the Russian criminal legislations, which the occupying power extended to the occupied territory within limits unpermitted by international law. And my final remark is that when we answering to questions whether this court could help properly consider war crimes and crimes of humanity in Crimea, I would say there are 2 common obstacles, I guess, for every court, be it in domestic or international, when it comes to Crimea. First, is that such court in any domestic court currently does not have temporarily lacks territorial control, so it cannot properly collect all necessary evidences. And second is that many victims and witnesses may fear for their life and security, fearing reprisals from the occupation authorities. From our experience, we observe that it's a widespread practice when victims or witnesses are fearing reprisals. I guess that's the same case for the territories controlled by the so-called DPR and LPR. So full-fledged investigations and bringing perpetrators to justice could be much more fruitful when Ukraine regains control over the occupied territory.
Great. Thank you, Evgeny. Let's now turn to Tatiana for the last word, and go ahead and share with us, Tatiana, your thoughts on funding or any additional thoughts you have, and then I will close us out.
Дуже дякую, Пол, за
Thank you so much, Paul, and thank you. It is an interesting question, really. The matter of funding, first of all, ensures the independence of the judges, and on the other hand, it's vital for the operations of the court. We don't have much time, I see that, so I'll be very brief commenting it. So I wanted to say that we need to understand where international financial assistance would be appropriate. And in order to do that, we need to look at the procedures and how this court would be created, according to which national mechanisms. My colleague Rasim Babanli has already mentioned that the Higher Qualification Council of Judges and the High Council of the Judiciary are being formed, and they say that they will finish the creation of these councils only in December this year. So most probably they will start functioning in the beginning of the next year. So if we expect that this new High War Crimes Court will be created according to the national procedures, we have to really calculate the budget for that. Starting from the beginning, when we start the selection process, we announce the vacancies. Usually it's part of the budget of this high qualification committee, and no additional funding is needed. But the assessment as part of the competition would be the main thing. There should be somebody who will develop the tests and the case studies. There was the National School of Judges in Ukraine who did this in the past for the creation of other courts. However, there was also the experience when third parties were engaged. So I think international experts can actually be very useful here, and the donor aid would be very, very helpful in the selection process, in the creation of the tests and case studies. And this School of Judges has its budget, and it will cover day-to-day operations. But if we have a lot of candidates, the Higher Qualification Committee of Judges, well, it has its premises. So to start the assessment, they can be assessed there. So we don't need extra resource for that. Then checking the tests, this can be done, and then interviews. And of course, the biggest expenditure also would be the premises for the new court and the salaries of the judges and the salaries for the office of the court. And if we want to calculate the maintenance rate, for example, we can look at the higher anti-corruption court. It's all public information, and it's there, it's in the budget. So we can probably extrapolate. We can look at the budget of the higher anti-corruption court and then see how much per year would be needed for this high court on war crimes. So this was my comment. Indeed, we have to think how to best get international assistance without having a conflict of interests and while keeping impartiality, because we have to consider that this is not a hybrid court, but this is a national court, a domestic court, which has to be created following domestic legislation. Thank you so much.
Great. Thank you, Tatiana. Well, let me close by thanking all of the panelists for your insightful and engaging commentary, to the team for drafting the statute. I also wanted to thank our 400 registered participants for dialing in and spending their lunchtime or their afternoon with PILPG. And then also a thank you to the backstage PILPG team, which has answered about 12.5 questions in the Q&A, and to Katerina for being very actively engaged in answering those Q&A as well. So wishing you all a great afternoon and a great evening, and thank you again.